Welcome, everyone. Happy Thursday. We're going to give everyone a few seconds to join here. All right, while everyone's beginning to join, we can go ahead and get started. So welcome, everyone, and thank you for joining us for today's webinar, Client-Friendly Billing Practices, with our guest speaker, Jacqueline Vinaccia. We also have Ryan Lowe from our customer success team joining us for this webinar to help out with any MyCase specific questions. And my name is Allie Skilperort, and I'm the marketing associate at MyCase. And MyCase is a law practice management software that takes care of your daily practice requirements for calendaring, contact management, document management, time and billing, client communications, custom workflows, and more in one solution at an affordable price. And MyCase is priced for small firms at just $39 per month per user when billed annually. And in today's webinar, we will be discussing the top ways firms can streamline billing practices to reduce costs and maximize efficiency. And now it is my pleasure to have our guest speaker introduce herself.
Hi, everybody. I'm Jacqueline Vinaccia. I am a partner in a 3-woman firm here in California. We are all based in San Diego, but we do work all over California. I'm the firm's litigator. I do all the business litigation. We like to think of ourselves as a one-stop shop for small businesses. As part of my career, I worked in big law for about 14 years and enjoyed it, but felt like it was time to get out and do some smaller stuff. In that process, I started doing reviews of attorneys' invoices for insurance companies on allocation issues, for prevailing parties, for non-prevailing parties, and in a lot of other instances where clients and or the court are questioning billing and the award of attorneys' fees. So that's where I get to you all today. I have done my fair share of analysis, testifying in deposition, arbitration in court, and I'm happy to share some of the knowledge I've gained with all of you and make you able to get past me should your bills ever come to my attention.
Perfect. And thank you for being here, Jacqueline. We really appreciate it. And before we get started, I want to cover a few housekeeping items. We love taking questions from our attendees, so please feel free to send in your questions throughout the webinar, and just make sure to send them to everyone so that everyone in the chat can see those questions that come up, and our speakers will do their best to address them either throughout or at the end of the webinar. We'll have a Q&A as well. And we'll also share the recording of this webinar with you after the webinar, so you can expect that to come in an email within a few days. And without further ado, I'll hand it off to Jacqueline for the presentation.
Thank you. Allie, I'm going to ask you if we get questions in the interim, if you could let me know if they're topical to what I'm talking about, because in the share screen, I don't get to see the chat.
Yeah, absolutely.
So lions and tigers and timesheets. Oh my, I love this, this slide because it gives an idea of how we feel when we are dealing with our daily timesheets. I can't tell you what the percentage is, but I know it's significant of attorneys who leave law firm practice because of the timesheet. And it's a difficult thing to deal with. We often feel like this poor zebra being chased down by this lion, and we're about to get gobbled up in some manner or other, whether that's not having any life other than work or not ending up losing our job because we're not doing our timesheets correctly. Having said that, so why is it that we think that timesheets are so stressful? Well, either we have so much work that we're not keeping track of what we're doing with our time and not putting it on the timesheet, and so we're losing it. We have too little work, which a lot of us have felt. So if you work in big law and you have too little work, you feel like you have to justify your existence as a lawyer. If you work for yourself, if you have too little work, you're not going to get paid. So no matter where you are, if you're working on a timesheet, the timesheet itself is stressful, and we're a service business. What we sell is our time and our expertise on what we do, and very few people understand the value that goes into the time that we expend. It seems like what we're doing on our timesheets can feel like it's never right. We're either over or under billing. We're either not explaining enough or explaining too much. So we end up in this situation that adds to what is already a very stressful profession. So I always add a couple of billing ethics to my seminars so that we get a little ethics on top of everything we're doing, because actually billing and invoicing our clients is an ethical billing issue. In California, we have our own professional rules of conduct, but most states, and now California included, follows pretty closely the ABA model rules on how a lawyer can bill their clients. Under the ABA model rules, a lawyer's fee must be reasonable. That makes you feel like you're back in law school again when you're in torts, and what a reasonable person would do, and how vague and ridiculous the term reasonable person is. In California, it gets even more clear by using the word unconscionable. So maybe we understand that better than reasonable. I tend not to think so. It seems to put the standard a little further out on how far you can push that window. The ABA has issued some formal opinions on billing, including what we're supposed to do as lawyers is do our work and prepare our projects for our client as efficiently as possible. And obviously, time spent billing or billing for time that wasn't spent on a matter is prohibited. We call that bill padding, and that's the rule or the term that most people use. I find anymore in smaller firms, I have a lot of clients who I work for on the auditing end, where I'm actually telling them that they may be underselling their time. So keeping track of your time so that you know what your time is and bill it appropriately to your client is going to be important, as we'll see later. So back to the complete understanding of what is reasonable. Both the ABA rules and California rules of conduct include a list of factors to help you decide what is reasonable. Some substantive areas of law command a higher billing rate. Certainly, the experience level of the attorney comes into play. If I do something, I've been practicing law now for 32 years, and if I do something in a half hour that takes an associate 3 hours to do, that's hopefully because of my experience and expertise. And I should be able to command a bit of a higher rate for the time that I spend, because I am more efficient now than I was in my 3rd or 4th year practicing law. There's also an issue of a level of expertise in an area of law. It certainly would take me a lot longer to go through and prepare a motion in an area of law that I am unfamiliar with, as opposed to the ones that I am most familiar with in business and real estate law, or municipal law, or even to some extent cannabis law, as opposed to dealing with a patent or IP. So the level of expertise of the lawyer also goes into that. The geographic location. I am situated in San Diego County, and when I file a attorney fee motion with the court here in San Diego County, my court is going to know that the attorneys in San Diego command a lower hourly fee than the attorneys do in Los Angeles or in Silicon Valley or in New York, and to some extent in Washington, D.C., all areas that I've had to research and find out what the usual rates are in those areas. So, and then that gets us back to California rule of professional conduct, where we're talking about an unconscionable fee. Most recently, I did an interview with Bloomberg where they were talking about lawyers billing 2,000 hours or $2,000 an hour. And the experience was compared to the $1,500 an hour rate that was being charged by Skadden Arps. And my point there was, is you might be stretching the rules of conscionability and credulity when Skadden Arps and Jones Day are your reasonable law firms, reasonable rate law firms, and are billing substantially 25% less than you are. So using all of these factors, you come up with a rate and a scheme that can help your clients understand the bills that they are receiving, because again, what we're worried about or paying attention to here today is client-friendly billing. I think the number one thing that's important on client-friendly billing is communicating with your client regularly and setting expectations. I tell my clients on a regular basis that I try to underpromise and overproduce. I will give them an estimate that is well over what I actually think it might take to take into account all those things that we can't foresee as lawyers, because let's face it, trying to estimate our how much it'll cost for a particular case to go to trial, get through discovery, or just this particular motion can be so dependent on what your opposing counsel does that it's darn near impossible to come up with a reasonable estimate until you've been doing the work for 30 years. And even then, I can't tell you that I come up with a decent estimate. So the rules of professional conduct do require that we keep the client reasonably informed about significant developments in the case. I would recommend for client-friendly billing and communications that you over communicate as much as you can with your client. Discuss what you are doing, the assignment that you are doing, and realistic time estimates and cost estimates for what you're doing. I am currently working on a case that is a probate case where a lawyer filed not one but two motions for summary judgment, both of which the lawyer conceded that there were triable issues of fact that would defeat the motion in the motion itself. So initially we are questioning whether or not those motions should have been filed at all. We can't have all been, or most litigators have been in the situation where you have filed a motion for summary judgment because it had some other meaning in the case. You needed to get some particular piece of evidence before the court, and you felt like you at least had enough of a showing on motion for summary judgment that it was worth educating your court to do this. That's something that you have to explain directly to your client. You are doing this knowing that there's a good chance that you're not going to win, but it's going to set you up for something else later. In our world, time is money, and that money is your client's money. And they're looking at their depleting bank account. As lawyers, we are a cost center. We do not generate any income. We pretty much usually just cost our clients money, and hopefully in the end resolve their case in a way that they either come out ahead or not as bad as they want to. And I'm speaking negatively from a litigation standpoint because litigation costs so much, which is why it's so important that we communicate with our clients. I think that the first place that you can really communicate with your client is in your retainer agreement. Address specific things in your retainer agreement, especially if you're going to end up in a situation where there's a prevailing party potential motion at the end of the day. If you have already identified to your client that you will be billing for certain items, I have in my auditing work, often we need to do a little bit more data entry work so that I can work with the individual billing entries than you would allow in a regular transactional or even litigation practice where clerical billing is not appropriately billable. I address that directly in those retainer agreements, because then I can, my client knows that I'm going to get, I'm going to bill for that particular task. I have even found a particular, and I just ran across this particular billing or not ethics opinion recently about double billing. The classic question is, if you are traveling, you're on a flight from one city to another for one case, but working on a different case where you're on that flight, can you bill for the time you spent working on the other case and bill for the flight for the initial case? In most cases, we assume that that is not billable, but in fact, if in California, if you have identified to both clients that that is going to occur and that you will bill that time to both cases and both clients have agreed, you can actually get away with doing that ethically. So what my point being that whatever you put in your retainer agreement is going to give particular weight to how and where you build that in your invoices. Another good topic for that, because one of the most controversial topics I run up against is inter-office conferencing. And if you address that directly in your retainer agreement, you are more likely to be able to collect that when you get to the end of your case or when your invoice gets sent out. So did I go one too far? The other thing you want to do is you want to make sure that whatever you're doing is providing some value to the case, or some value that your client can understand. So I suggest that you give your client something to hold, something to read, something to do. One of the continuing challenges we run into, especially as litigators, is we need all the information that the client can provide us, all the documentation that they can provide us. And having them collect that information and knowing and understanding the volume of information that or documentation that they sent to us, when we get around to reviewing it, then we can, they can understand how much time we had to spend reviewing that. Also, I have tasked my clients with particular things in the past where I have told them I can research whatever the issue is on the internet, and or they can do it and provide me that information. I of course verify it, but that gives them something to do. They realize that they spent 4 hours doing it, and at my rate, at a litigation rate of $500 an hour, they save themselves $2,000. So give your client something. When you've spent a lot of time on something, if you give them that motion, give them that research, or give them that task, you can help them understand what's coming in your invoices and why it took you as long as it did, or why it cost them as much as it's costing them. So, specific challenges for whatever I'm getting. here we go. Let's go with some specific challenges that we all have to deal with that directly go into specific client-friendly billing practices. One of the big things that I like to talk about in my seminars is billing for emails. Like I said, I don't know, a dozen times so far, I've been practicing forever. And I started out without a computer on my desk. My second job in big law, I did have a computer on my desk, still didn't have email. By the time I got email, it wasn't too long after that our senior partner at my firm said, don't bill your emails, because emails are too quick to dash off, and people, especially insurance adjusters, know that it doesn't take you 6 minutes to read an email and write an email. I see a lot of what I've listed in the billing don't, if you remember glamour do's and glamour don'ts, in the billing don't column there. I see a lot of this in my analyses, and I do call it out. Reading an email from somebody, drafting a response to that, reading their response back, and drafting another response to that. The reality is where you're having the functional equivalent of what we used to do on the phone. And the whole process probably took you about 10 to 12 minutes. And that in that case, I don't want to see an individual entry for each review, respond, review, respond. That'll make me think that the bill is, that's a red flag to me that the bill is being padded. I just go ahead on my invoices. I email back and forth with my client what we were discussing, or with whomever, and very briefly, and then give it a time increment. And you see in this case, the attorney billed, the attorney being me here, billed only half the time, but that's more accurate or indicative of the time I actually spent on that email chain. And let's face it, that email chain probably continued over the course of the day. So 30 seconds, you'd stop and answer the email, and then get another response back, another 30 seconds or so. But over the course of the day, it probably took you 10 minutes. So paying attention to that kind of stuff, your client understands that this is what has occurred, as opposed to read, answer, read, answer, read, answer for 0.1 for everyone. The other big area for client-friendly communications is making your billing entries understandable and not too vague. Vague or general billing descriptions will be called out and will be questioned, and there is plenty of law on this as being unacceptable billing practice and subject to reduction by courts if you're on a prevailing fee motion. For instance, legal research, 3.2 hours. Legal research on what? I know that we can do a lot of legal research in particular motions. I like to break down my billing entries so that, especially for research, so that they show the different issues that I was reviewing at the time, or researching at the time I was doing that. So time entries, of course, should include the attorney, the date, the time expended, and I say attorney, that can be a paralegal, any biller, and a description of the work sufficient to evaluate its appropriateness. So the evaluator can either be me as the expert, but in fact, at the end of the day, the evaluation of the appropriateness is done by the court, and I'm just there to assist. So I put in a specific date, research proper billing techniques for the fee recovery motion, 3.2 hours. So that makes sense that that's that could have taken me 3.2 hours. If you're doing a motion for summary judgment, it could be a standing issue. It could be you could have 4 issues in the same motion that identify and reasonably take 20 or 30 hours to research. But if you break down the research chunks into what you were doing, you're much more likely to get your client to understand what it was that you were doing, that your specific task and what you were researching today is different than the one that you did yesterday. And then again, that's more likely to get paid with less challenge. Intra-office conferencing. This is probably the most controversial thing that I deal with in my audits. If you're working for an insurance company, you probably have billing guidelines that probably say, don't do it. Just don't bill it, don't do it. I do understand that and everybody understands that some coordination between counsel is appropriate and probably billable in a lot of cases. But what I end up seeing, especially in big law, is a pattern of anytime anybody stops to talk about a case for 5 minutes, they bill 20 minutes to a half hour to it by both attorneys, which can add up to, I've seen cases where the inter-office conferencing is 30 to 40, can be 30 to 40% of the bill, and that's just not efficient. You haven't added value to your client's case. You haven't shown your client the value of what you're doing. I try to keep my inter-office conferencing billing to a minimum. If I am working on an opposition and I stop to talk to somebody about something that I know that they did before, hey, can I have a copy of this because I know you've done this before? That's not a separate office conference. That's part of my preparation and my research for the opposition. And I would bill it in that way so that there's an understanding that that was part of what you did as the opposition, as opposed to these meetings of 3 to 5 people to pick each other's brains or brainstorm a case. That ends up being horribly efficient and can cost the client that literally $2,000 an hour once you count up all the attorneys who are sitting in the room. I recommend keeping as many inter-office conferences off your invoices as humanly possible. This is probably the easiest way for you to record your time accurately and keep your communications with your clients current is real-time recording. We all get busy and we don't write down our timesheets. I used to have a partner who waited until the end of the month to input all her timesheets, all her time. She might write notes to herself here and there. There's also the times that everybody sits down and I know everyone has done this, where you realize, oh no, I didn't do any billing today. And you go back through your emails to figure out what exactly you did and what cases you spent time on. If you can do this in a real-time basis, contemporaneous recording of your time, studies have shown that you will capture approximately 20% more time because you lose it because you forget. And if you write down what you were doing while you were doing it, your billing descriptions are more accurate and are better received by your clients. We're tasked as lawyers with using what is called by the court as good billing judgment. Also a completely understandable term, like every other legal term we deal with. What I like to say to people is to look at their bills. And if you're an associate, ask your supervising partner if you can review your pre-bills, because it will give you a great deal of perspective on what it looks like when a client gets a bill and how they read it. Some clients read every line. I have had clients who have money to burn who read every line of my invoice, and clients who have almost no money and just see the total and pay it. So you can't say which client is going to read line by line, but if you read your bill line by line and ask yourself, if I were this client, would I pay this? Was the task beneficial to the advancement of the case? And are all of these entries sufficiently described to convey that information to the client? Chances are you will be found on a prevailing attorney fee motion, or in the mind of the client, you'll be found to have issued a reasonable bill and will get it paid. If at any point somebody asks you, I don't understand what this means, and you find yourself having to explain more of what was in that billing description, then chances are you didn't fully describe it in the first place. I take that position when I'm writing something. If I ask somebody to proofread one of my documents, my motion or something, and they tell me this paragraph doesn't make sense, but it makes perfect sense to me, that means that the judge isn't going to think it makes sense. So I rewrite it to make it more simple. Take that into your billing as well, because remember that your client is not a legal professional in most occasions. And although they may be business savvy, they may not understand some of the legal terminology you place in your bills. So looking at other fee arrangements, and I think I skipped a slide in there. There are several different types of alternative fee arrangements that you can use too, that are can be incredibly client friendly. My partner does a lot of putting together, setting up LLCs, corporations, limited liability partnerships, and she does a lot of flat fee arrangements for that initial setup. I know a lot of trust and estates attorneys will do a flat fee for the initial trust, and then the follow-up or amendments to the trust are done on an hourly basis. The pros for flat fee arrangements is that it sets an expectation for a client. They're going to pay this amount of money up front, and based on what you've written in your retainer agreement, this is what they're going to get for that. And also on your end, it prevents collection problems. And anybody who works in a small firm, works for themselves, knows that we spend entirely too much money chasing receivables and hate it. For those of you in Big Law who don't have to do that, that's wonderful, or have a actual accounting department who does that for you, that's also wonderful. But at some point, I think every lawyer has to review questions on their bills and respond and follow up on collections. What the cons to a flat fee arrangement are that sometimes a particular piece of our particular project can take more time than you anticipated, and that decreases your overall profitability in that. And in some other cases, it may not allow time for creativity. Now, what I do I have a line of flat fee cases that I call hybrid flat fee cases. And what these do is they set a flat fee to a particular point in the lawsuit. I have a line of collections work that I do for a friend's company, and we have it set where they pay me a particular amount up to a particular point in the lawsuit. If I'm able to file a lawsuit, get the debtor to respond to me, negotiate settlement, there's no more fee on that case. if we have to go to some kind of motion work, if I have to serve somebody, request ex parte relief to serve somebody by publication, then it rolls over into an hourly fee arrangement with that particular client on that particular account. You can also, I know a lot of attorneys also use stepped fee arrangements, which is from one point to a particular point. In litigation is easiest for me to identify because that's what I do the most. Say from intake of a case to filing and the complaint and getting an answer is a particular fee. Once you get the answer and it appears that there's going to be a certain amount of written discovery, there can be another flat fee. If it appears that it's going to go into deposition discovery, there can be another flat fee, and there can even be another flat fee for trial. The same thing can happen in a transactional case where my partner might set a flat fee to set up the corporation, and then a particular flat fee year to year to do your corporate formalities, your yearly meetings, minutes, etc. And then if there's more stuff to be done, adding partners, things like that, then you can create another flat fee for that. Anything with regarding flat fees or any hybrid flat fees, they are all appropriate under the rules of professional conduct, ethical rules. If you document what the steps are and you communicate those to your client. Always for ethics, just think about if you're telling your client and you're getting some kind of approval or sign off from your client, you're probably going to be okay in as far as ethical rules go. So this is my favorite part. This is where you get paid, because like I said, we all like to get paid and to, I mean, that's the point of what we're doing. I love this little guy because that's how I feel when I get a check. If you've used good billing judgment, if you've communicated with your client, if you've given them reasonable estimates, your chances are you're going to get paid. If you've done some pre-work collection, and I'll give you, I have a line of work, especially I do some cannabis work, and I love my cannabis clients, but cannabis business people are just kind of a set apart as far as business people are concerned. They always pay me, but kind of when they get around to it on that particular line of work, I will often do a replenished retainer just so that they know I have this much money. I don't have to keep calling them for you owe me money, and we can keep our relationship, our business relationship going well without me having to constantly ask them and request payment. And no matter what happens, you're going to get in a situation where you might need to request payment. And if your invoices are understandable and you've communicated with your client along the way, you're going to be in your best position to get the client to make those payments. So I noticed that we have like 7 statements in the chat, but I can't see them.
I don't think any of them were related specifically to your presentation, but this would be the time now for anyone in our audience. If anyone has questions, you can go ahead and send them in the chat.
Okay. I saw a raised hand.
I saw that too. Let's see. Someone asked, can your sample engagement letter be shared?
I probably could, yeah. If anybody wants to contact me after the fact, I can probably send. And when you say sample engagement letter, you're talking about the flat fee engagement or my regular engagement letter?
She said both, please.
Okay, yeah, I can provide those.
And then someone also said, where can we find sample flat fee agreements?
Where have I found flat fee agreements? They're kind of all over. I know that the bar has some language for flat fee agreements, but I can find some references and provide those. I like this question, how do you best communicate with clients without overcharging them? I am very careful when I'm talking to a client that I try to keep the telephone conversation to a minimum. And the reason that I say that is because it is difficult for clients to understand that you're charging them for telephone time. And that's more when you have a private client as opposed to a business client or an insurance client. So I keep that to a minimum and as much writing as you can provide to your client, because if you're just you and your client talking, that of course is attorney-client privilege communication, and that gives your client something, like I said, something to hold. They can see what your work was in doing that. And I always ask my client for any further questions, any thoughts at the end of my emails, so that they can let me know if they're missing some point of the question or the issue.
And Robert asked, do you believe there are any problems sending client bills via text?
As a litigator, I have a lot of problems with texts because people don't tend to understand that texts are a writing. I think that if you and your client are clear that invoices are going to be sent via text, and I would guess that is a link, because you have to send an invoice, a detailed invoice. Yes, I think you can do that. I would document that in my retainer agreement. But I'm still at a point where text makes me uncomfortable, because people text as though they're talking without realizing that they are leaving an actual typed paper trail.
And looks like Ruth said, in a flat fee practice like immigration, how can unreasonable number of calls be charged?
I have had that happen in a couple of my flat fee cases, and it's either phone calls or strange things are happening. The retainer agreement says that these things are covered under the flat fee, and if anything outside of that occurs, that the attorney will contact the client and let the client know that they've triggered the hourly rate or whatever that is. I like to, if you have a flat fee rate, I like to include, if you can, especially in immigration, because you are going to get a lot, immigration and family, you get a lot of very scared people who are calling you a lot. Give them an understanding of how much time, phone time or email time is included in that flat fee arrangement. And that if it exceeds that there will be a particular surcharge, whether that's hourly or the next step up in rate. By setting expectations early for the client, you're going to get 2 hours, you're going to get 4 hours of my time a month for this rate. Then they know. It's hard for clients sometimes to understand that what we're selling is our time, because we could certainly do this job 24/7.
And then it looks like we had a question earlier in the chat that I missed. Cynthia asked, do you have any advice for criminal defense billing?
Criminal defense billing, I don't have specific advice for, other than it seems to me that it is as important to be as detailed as you can, because you are, again, dealing with private clients who aren't necessarily particularly legally savvy and don't understand the amount of time you spend in a day. So I think the more detailed you are, there's an issue that comes up a lot in billing regarding block billing, where you just write down everything you did for the day and it took you 4 hours today to work on this client's case. And I'll be the first person to tell you that some days I want to write down just working on your case, okay, 4 hours. Block billing can be difficult because it makes the bill difficult to analyze. If your client is fine with that and nobody's ever going to pay you for that bill other than your client, then I don't see anything particularly wrong with block billing. Where you run into problems is if you're going to ask a court to parse out what is recoverable on a prevailing fee motion, what is covered under an insurance policy as far as defense fees, what is what was done to enforce the contract, where you're asking somebody to break apart blocks, you're going to have trouble getting past whoever the analyst is. And I would recommend doing as much line item billing in that case as you can.
And we'll address maybe 2 more questions and then start to wrap it up. Someone said, how do you coach your accounts receivable person who is not a legal team member to field clients' questions about their bill and explaining the work done?
Usually if somebody's got a problem with a particular amount on the bill, I would have the accounting person take down the questions instead of having them try to justify the time you billed. If they're questioning the invoice, that's going to come back to the biller, the attorney, and whether or not that's the associate attorney or the supervising partner. In our firm, that would be me as the supervising partner would look at what the client is questioning and make a determination on that. That's why I recommend to all of my associates and younger attorneys that they bill all their time, because then the reviewing partner can decide if they spent too much time and shave some time off of it, or no charge some of it, or at the end of the day, create a discount for that to make the client happy. If you're not putting down the time that you spend on your timesheet, then it could be that you're also missing a chance to create a more billable time that goes out to the client and is paid, or sets up a situation where you can give a discount and make the client happy because they feel like they got a discount.
Okay, and one final question. How do you address refunds when clients do not complete transactions, but there is billable work completed? Do you have a flat percent that is refundable on flat fees in your engagement letter?
That's difficult on a flat fee. I haven't had a flat fee where I've needed to refund. How you deal with that is you identify the place in the case where the flat fee is earned. In my particular cases, the flat fee is earned where I would have to file a motion to withdraw to get out of the case. And at that point, that's what I put on the bill, flat fee earned, and show the transfer from my trust fund, my trust account, to my actual account. If a transaction is not completed because for whatever reason, it doesn't matter, it's up to the attorney to identify how much of the work was done and what percentage, and create that refund back to the client. And I would highly recommend communicating with the client exactly what you're doing and why you're doing it, so that you're setting up that paper trail of how you decided that, in case the client comes back and wants more of a refund or requests a mandatory arbitration, which we have in California over fees, which I spend a lot of time arbitrating. So the better paper trail you leave as an attorney for why you did what you did, it also ends up to your benefit.
Awesome. Well, that is all the questions, it looks like. And thank you so much, Jacqueline, for your presentation and sharing your insight with us. I know it'll be really beneficial for all of the firms that have attended today. And before we wrap things up completely, Jacqueline, if you want to just go to the next slide for me, we're going to launch a couple polls. So if you all could take a few seconds to vote in these, they're going to pop up on your screen. So we'll launch the first one now. Give everyone a few more seconds to vote. We keep that up for about 10 more seconds to get your votes in. All right, we're going to go ahead and launch the next one now.
Oops, sorry.
And in this poll, if you are a MyCase customer, you can vote that you're a MyCase customer in this one. That one up for a few more seconds. All right, and then you can go ahead and go to the last slide, Jacqueline. So thank you again, everyone, for being here. And I hope you all have a great rest of your week, and keep an eye on your email for that recording later. It will land in your inbox within the next few days. So keep a lookout for that. But hope everyone has a great rest of the week. Bye, everyone.
Thank you, everybody. I received a bunch of emails and I'll respond to those. Thank you.
Thank you, everyone.